the problem that my lady poses, in theory, would mean that almost all of the cases that have been decided by this court and below, including MCA and Charlie, were probably wrongly decided. Now, instinctively one says that's probably not correct. Therefore, there must be a solution to the problem. And I think that the problem, may I just, as an example, take the case that we were looking at with Sun Care, which is the lifestyle case, and just see how close factually that case is to this one. Now, one starts at paragraph 20. In paragraphs...
Hold on, just remind us.
Tab 35.
Tab
35.
Thank you very much.
Paragraph 20. In paragraphs 41 to 44, the judge considered the facts and evidence relating to Mr. Ahmed. The evidence showed that the company D11 was a family-owned SME with a number of employees and a substantial turnover. Mr. Ahmed was the managing director, and he took a close, active and personal part in bringing about the activities found to infringe. He was responsible for choosing what brands to put on the goods. This is, as one appreciates, it's a registered trademark. He chose the factories to make the goods found to infringe and agreed prices with them. Complaints about confusion were brought to him, and when talking about D11 sales and what happened in offices and showrooms, Mr. Ahmed repeatedly referred to himself personally as doing those things. Mr. Ahmed contended he had no improper motive, that he acted on advice, that he delegated design of the logos to a professional design team, that the company was not a one-man company, and that all the other shareholders took an active interest in running the company. The judge held at paragraph 43 that none of these purported defences amounted to a defence in law, and went on to hold at paragraph 44 that Mr. Ahmed was jointly and severally liable with D11 in relation to the infringing acts. The judge also has said that it was not necessary to distinguish between authorising and common design, because the same facts established liability on both bases. In relation to Ms. Ahmed, the judge held that she was not liable for wider infringement activity of D11, but was liable for infringement of a division called House of Brands, and so on. Then we go to the next passage we need to go to is paragraph 49. Having considered all the authorities, putting the things together, my judgment, MCA and Charlie represents the law on this topic in England and Wales. The protection for a director identified in Lord Justice Chadwick's first principle is not strictly confined merely to voting at a board meeting, but it's a narrow protection limited to exercising control through the constitutional organs of the company, albeit that may be something which can be delegated. Now, directors seeking to avail themselves of that principle of delegation in order to escape liability will need to prove that that has taken place. In any event, simply showing that the director has acted properly in the sense of not acting in breach of their fiduciary duty is no defence. In the present case, and this was the trial was done in a split way, so the Ahmed's position was considered second after the company had been held liable. In the present case, the close personal involvement of the Ahmeds in the acts of trademark infringement meant that they do not come near to bringing themselves within the protection afforded by the first principle of MC and Charlie, or the possibility of delegated authority identified in autocraft. The fact that neither Mr. Ahmed nor Miss Ahmed can be said to have an improper motive or to have known or been on notice that the actions were likely to amount to trademark infringement makes no difference to their liability, nor does the fact that Mr. Ahmed acted in advice, the fact the Lego designs were delegated, or that the company was not a one-man band. The judge was right to hold that none of these points amounted to a defence in law to the claim that they were joint tortfeasors, and he was entitled to reach the conclusion that they were liable on the facts. So there must therefore be a principle underlying this, because if one looks in our own case, all that the judge at paragraph 14 found was, it's page 63, tab 5 of CB1. The combination of the above features is entirely sufficient to persuade me that the agents and sub-agents had authority to make the representations, which they then made by handing over the DVDs and brochures and making statements as to buy-to-let and rentals, and the special mortgage arrangements in accordance with their training. And then he says, goes on to find compelling evidence, all the more so, as to that. And then we don't need to look at the rest of paragraph 14. So, and clearly in the preceding parts of paragraph 13, the judge had described the involvement of Mr. Ioannou. Now, he doesn't at paragraph 14 explain the basis upon which the acts, the authority was given, what basis of law. He simply says, and it could be that he finds it on the basis of ostensible authority, implied authority, or actual authority. He just doesn't spell it out. But I think one's got to confront the point rather than trying to fudge it. And it seems to me that the only way that one can say that the principles are consistent with the position which was the point put to me by my lady, is that the authority which may be given to do whatever it is that is done does not include an authority to do an act which is tortious. Because otherwise, in other words, the act of authorizing publication is an overall act. As it happens, that act has included a tortious element, which is the omission of a warning as to risks, which is the tort which the learned judge, the tortious act which the learned judge found. Then one goes to the, and that may have engaged Mr. Ioannou in a capacity, and that's the difficulty. What capacity does that authorize him to do? Because it cannot, I think, have been an authority to commit a tort.
Well, if the
or to commit the company to a tort.
If the tortious act is an omission of a warning as to risk, as you submit,
yes,
and as the judge found, then there is no common design to do that, is there?
Well, yes, because it was obvious to the company, as it was obvious to him, that there was a risk and that there was a need to include in the documentation a warning, so that the common design is the publication of documents which actually do not include that warning. In order to disentangle himself from personal liability, under the principles of MCA and Charlie, Mr. Ioannou has to establish that actually what he was doing qua individual came within the ambit of what was delegated to him in his capacity as a director. And one looks at MCA and Charlie, paragraph 50, And we can pick it up much quickly if we don't mind. Well, MCA records, tab 37, paragraph 50. And it's the last part of paragraph 50. It's 5 lines down. In other words, if in relation to the wrongful acts which are the subject of the complaint, the liability of the individual as a joint tortfeasor with the company arises from his participation or involvement in ways which go beyond the exercise of constitutional control, then there's no reason why the individual should escape liability, because he could have procured those same acts through the exercise of constitutional control. And one can see situations where the company is liable for authorizing something, but the individual does not have that necessary element of personal exercise of his acts through constitutional control. At the moment, I can't think of a more elegant way of putting it, because it's taken me slightly by surprise, and it's a point which hadn't occurred to me. But there must be a distinction, because otherwise, that most recent case, MCA in Charlie itself must have been wrongly decided, and so on. So, if the point made by my lady, the Assistant Lord Justice Phillips, is right, it's a showstopper in the sense that almost never can there be an ancillary or accessory liability of a director in cases, and a fortiori in cases of the one-man band, because he's effectively authorizing himself to do whatever acts he's doing. And that cannot have been the intention of the creating this special exception on grounds of public policy to allow a director to escape from liability, which he would otherwise have. So that one, and the underlying public policy is, it's a very narrow exception, because otherwise people should be liable for their own acts which are tortious, regardless of what their role is within the company.
Well, it's a narrow exception for the reason that given by Lord Justice Burse,
yes,
which is that there's no it's para 38, isn't it? That if you would be liable for personally procuring a trademark infringement and assisting in the infringement pursuant to a common design to bring about the act of infringement without necessarily knowing it's an infringement, you shouldn't escape liability for that simply because you're a company director, when somebody who isn't, but would also be acting as an employee, would not escape liability.
yes.
Now, one sees the logic behind all of that.
Yes.
So it seems to me that the key question has always got to be whether the act complained of is one which would attract accessory liability tortiously if the person concerned were not a director. You then have to ask yourself, why should the fact that he or she is a director make any difference?
Yes. And the answer is that narrow exception, that he's actually, or has power delegated under the constitutional organs of the company. Essentially, I'm afraid it really does come back down to the point that I think I've made a number of times, we made in our schedule, which is this exception doesn't actually quite feel right.
No.
And that's the difficulty. And it's been created as a matter of public policy, but yet it just doesn't sit right. And the answer may be that there isn't or shouldn't be such an exception, because the individual is liable. However, he's entitled to be indemnified by the company.
The answer may well be that one shouldn't need the exception because the rule shouldn't be there, and it's driving a coach and horses through Salomon and Salomon. But we can't say that. We're obliged to follow what other
yes.
courts of appeal have said.
Well, the I do think this is actually a point which has not been satisfactorily answered by MC and Charlie, and the cases that have followed it, and indeed this court in Lifestyle, in which the Court of Appeal last year came to the conclusion that that sets out correctly the law. Now, it may be that this court has found a serious flaw, but I think I fear, I say with in a sense of trepidation, because I was trying to persuade you only yesterday to the opposite way, that you shouldn't be bound by an earlier judgment of the Court of Appeal, but in fact, if point is a correct one, then it may be that a whole raft of Court of Appeal decisions are wrong. But inherently, if I might say so, one's instinct is to feel that they cannot be. I've sought to find a rational way through in the circumstances of this particular case, because the judge doesn't explain the basis upon which he says that the sub-agents were in fact, or as a matter of law, authorised. Doesn't explain what the legal basis is, so that in that sense there is a route which this court can follow.
One can see that it's fairly easy to find a route for the tortfeasor director to be held liable in straightforward cases of intellectual property infringement, because not only is it a strict liability tort, but in all the cases where the director's been held liable, he or she has been personally responsible for orchestrating the act.
Yes.
In a deliberate way.
Yes.
So, for example, in one of the cases, it was the importation of the infringing copies, coupled, I think, with an indemnity against any losses that might arise in consequence of doing so. So at least alive to the possibility that they might be doing something wrong.
Yes.
Although one doesn't need to have direct knowledge that it is. So you've got a strict liability tort there, and you've got accessory liability in the sense of a personal stake in the action by deliberately going ahead and directing that act to be carried out and procuring it to be carried out. I think the problem with this case is not only do we have a non-strict liability tort, but an act which is only tortious because there is an omission in it.
Yes.
That's what makes this case more difficult. It's not a case of go out and make this representation on behalf of the company. Representation turns out to be untrue.
It's don't make this. Don't say this.
It's say this, but well, it's not don't say this. It's say this, but only this.
Only this.
Well, it's not even that. Can we just look at the way you put your case on common design in your skeleton at paragraph 27, tab 15, where you say there must be a common design, and then the common design, as you define it, is that both he and the company had the common design through his master plan to sell as many properties in the developments as possible. Well, fair enough, but what you don't say, and perhaps couldn't say, is that there was a common design to do so in a misleading way by failing to give a warning. I mean, they just didn't think about that.
Well, yes, but it isn't. But you're not looking at the. You're not looking at the. You're looking at the act itself. It's not that you're looking, and if it's an act that turns out to be tortious, that's more than sufficient. You're not looking at the further additional part that my lord adds.
Well, no, the fact that there was no warning renders the company liable liable because the company is in a relationship whereby it has assumed responsibility, but Mr. Ayano is not. He hasn't assumed any responsibility, and he isn't party to any common design to omit a warning.
But what he is party to a common design to publish material which does not contain a warning. And the judge has found that it was obvious to the company, and therefore it must also be obvious to him, that such a warning ought to have been given.
I think my Lord's point picks up on Lord Staines's comment in Williams, doesn't it? That you can, that if liability of the principal tortfeasor is based on an assumption of responsibility, and you haven't been involved in that relationship, then you won't be a joint tortfeasor.
But that's always on the assumption of liability and the nature of the special relationship, which is created why I've been so careful to avoid looking at that, because, and taking your lordships to that line of authority, because it is actually completely different.
No, but Lord Staines was there looking at joint tortfeasor, not at assumption of liability.
Yes.
I mean, very briefly.
Yes. Whereas all the other cases do to a greater extent, much greater extent, actually focus on as their ratio decidendi upon joint tortfeasor. I don't pretend to have found the ideal solution, but it seems to me that if this case is to be treated on a par with all the other cases, then there is nothing really to distinguish this case from that of
well, you mentioned the facts of lifestyle and the two Ahmed.
Yes.
Mr. Ahmed and Ms. Ahmed.
Yes.
But were they directors?
Yes. And more importantly, he was the managing director. So, of an English company. So we don't have any of the shadowy doubt as to clouded by Mr. Joanne's evidence about there not being a managing director, and he's not the managing director.
I can see a situation potentially arising where, let's say you've got a board of directors of 6 and a managing director of Counsel. And that managing director is in a Mr. Yuanu position. So although the board in general is responsible for giving the seal of approval, shall we say, to the issuance of documents, the Mr. Yuanu figure has personal responsibility for their content and what have you. And all that the rest of the board do is approve what he has already given his imprimatur to. In those circumstances, it might be said by one of the co-directors, who is about to be fixed with joint liability, well, I wasn't personally engaged in this. All I did was vote in the board resolution which said that we would approve this plan of which Mr. Yuanu was the architect.
And therefore he falls into the MCA exception.
Yes.
Yes. But Mr. Joannou in that situation...
Because he is personally responsible for directing the act, which turns out to be the tortious act, then he doesn't, because he goes beyond the simply agreeing with it with the rest of the board. He's actually engaged himself in the act which amounts to the tortious.
You're then looking at the distinction between a general authority and a specific authority. I mean,
I don't think one even needs to go there. I think it's the nature of the... It's the stage before in the analysis. It's the earlier stage of the analysis. It's what is it that foists him with personal responsibility.
Exactly.
Because if we come back to what Lord Justice Burst says in Lifestyle, what he's saying, and you can see the sense behind it, is why should somebody escape a liability that they would otherwise attract merely because they have a label of company director attached to them?
Yes.
To which the normal answer is because a company can only act through its directors, and therefore the fact that the act is done by a director shouldn't necessarily foist him or her with personal responsibility.
And it's the quality of the way in which you act in as a director, because as paragraph 50 of MCA makes the point, that if you could have done it through the mechanism of the organs of the company, then or the constitutional organs, then there's no liability. But if you don't, then that's not good enough.
I must say that
I have to say,
find a great deal of difficulty with the concept that if all 5 members of the board sat round a table and decided that they were each going to have a say in what went into the literature, and then gave it a rubber stamp of approval at a board meeting, they'd all escape liability.
That's what MCA says.
But I can see the distinction between the passive director who,
of course,
who votes and is doing no more than voting on behalf of the company to give the company seal of approval to a course of action, and the active director who is personally involved in the nitty-gritty.
That may well be the way through in the right analysis, that it's the active director needs to show that actually he has got authority from the board which actually covers that particular activity. And for that reason, of course, it becomes then all the more important that as part of his defence, he brings forward the evidence based upon the Articles of Association, board minutes, or whatever else there may be, in order to show that he is, like the other 5 in my latest example, to be excluded from liability because...
That's why I have difficulty, because it seems to me that everything is derived through the authority of the board, delegated down through the appropriate officer.
Unless he's acting on a frolic of his own, in which case whatever he does is not going to bind the company anyway. Yes.
Well, I think one of the difficulties is that in real life we've all know that companies don't operate with punctilious board meetings and so forth. And usually the smaller the company, the less punctilious they are about it, but nevertheless there's still that if they are going to get into that narrow exception allowed by MCA, it's only through that punctilious adherence to the internal bylaws of the company and structures that it allows them to be excluded. To my way of thinking, I'm afraid it doesn't actually make much sense, as I think it is my Lord Justice Phillips also, in a sense, is feeling. But if one, I fear that at this level, my Lord and my Lady are all stuck with the previous decisions of the court. And it's going to be very difficult to find a way through, short of actually saying that all these cases have been decided per incuriam or whatever.
Well, they're all intellectual property cases, and they're all cases of torts of strict liability. But
respectfully, that can't be the touchstone for accessory liability.
No, well, that's.
But is there a case? Is there a case where effectively, and I appreciate you say that Mr. Young's father was also a director, though I think the gist of your cross-examination was to the effect that was technicality rather than reality.
Well, no. I think actually no. I think looking at, if one looks at it carefully, what Mr. Joanna was saying is, I was trying to say it wasn't, and he was saying no. He is, but in terms of dealing with the outside world, because he doesn't speak English, I get authority. I get powers of authority to deal with specific situations because he doesn't speak English. And I think
I never get to finish a question.
Oh, I'm sorry.
Never mind. Let's move on.
All right. Does that complete what you want to say? Or
well, Lord, I think that does, subject to. Forgive me for a moment. Maloney Jr. suggests that there may be a stage at which, in the course of the principle, one actually needs to have a qualitative assessment of what the director's personal involvement is. In other words, you distinguish between him in his role wrapped up as a director and his role as an individual, the difficulty being that then that may be as unsatisfactory as any other test, because if you're wearing, I mean, you can sometimes distinguish, but it may be also quite difficult in many situations. Hence,
let's suppose that you have somebody who is not an employee of the company, but is a separate contractor, let's say, a consultant. Mr. Ioannou calls in a consultant and says, I want you to design some ritzy brochures for us to promote our new development and so forth. And that person dutifully carries out the work and produces these brochures in accordance with his instructions, which talk about the loan and everything else, but they miss out the key words about the
risk.
the risk. Would he be liable as an accessory?
Answer, probably yes. It depends. Then you've got to look. It's a fact-intensive inquiry to see actually what it is that he has done in terms of his responsibilities under whatever contractual arrangement, and the solution lies in what in Fish and Fish lies in then, as between the two joint tortfeasors, the court makes an assessment.
Well, I follow that
of,
afterwards, but
of contributory negligence.
I'm interested in the primary question, because if somebody in that role did exactly what Mr. Ioannou did, which is to supervise the, let's say, devise the wording of the sales pitch, produce the brochures and sign them off, do all of those things and then pass them on, you have to say that that person would have an accessory liability.
Yes.
Because if you don't, then it's difficult to see the basis on which Mr. Ioannou would have it.
Well, yes. Well, the only reason why we say fact-intensive inquiry, because you need to look and then see what the contract says between the company and the consultant as to what necessarily are the exclusions or disclaimers. But
well, that comes very close to saying that the consultant's liability depends on what responsibility he has assumed.
No, because he has, well, on the face of it, he would be liable. Actually, no. On reflection, he would be liable vis-a-vis third parties in any event. As between the company and him, he may not have any, he may be able to ask for a contribution, for an indemnity, but as between the public and him, then he would actually have full liability as an accessory. I think it's an intellectual knot, which I hope at least I've helped try to solve. I fear that in a way, because
well, you've pulled at a few loose ends, and we'll see where.
I'm grateful. I don't think there's anything further that I want to say about the.
No. All right. Thank you very much indeed, Mr. Parker.
My Lord, my starting point, my Lord, my Lady, my starting point is to pick up on what I understood to be a concession made by my learned friend, Mr. Nathan, I'll be corrected if I'm wrong, which was that at paragraph 62 of the learned judge's judgment, he asked himself the right question. And if that's right, then this becomes an appeal on the facts, because if he has asked himself the right question, he's approached the matter in point of law in the right way. And the only question that then remains is whether he has applied the facts of the case to the question properly. And that, in turn, therefore, involves an examination of the facts that he has found and considered, and whether those facts take him to the right side of the line for accessory liability, or keep him to the line, in fact, that he eventually chose. If that's right, and that's certainly, as I understand it, the position that appears to have been adopted on the judge's question as he posed it to himself at paragraph 62 of his judgment, then one needs to look, for the moment only briefly, at what it was that he took into account in coming to the conclusion that he did. And I've itemised those features that he took into account at paragraph 50 of my skeleton argument in this case. And
Sorry, just remind us where we find that. There are quite a lot of skeletons.
it's in CB1 tab 12.
Yes. Thank you.
And we can look, picking up the references there, to the various features, as he says, that he took into account in coming to his conclusion. He listed them very briefly, first off, in paragraph 59, as my learned friend submitted earlier today, in which, in paragraph 59 of the judgment, the judge said Mr. Ioannou is said to be personally liable for the claims because he was a Svengali, because that's one. 2, the marketing scheme was his master plan or brainchild. 3, it was his hub. 4, he was its hub, I should say. 4, he micromanaged at least UVR, if not wrote UK. 5, that he approved the content of the brochures and DVDs. And then 6, I suppose, that he was the only witness for the defendants, although I'm not sure that adds anything. And those were the features that he spelled out at paragraph 59. In fact, if one looks throughout the rest of his judgment, you'll see that he has analysed those elements of the claimant's case against the defendants generally at a variety of places, so that from the outset of paragraph 3 of his judgment, he says APP, of which the driving force is Mr. Ioannou, had a marketing plan, and he explains clearly what that marketing plan was. They entered into contractual arrangements, first with UVR, later with ROP UK, involving the supply and their sub-agents of DVDs, describing the developments, productions of brochures, establishment of a programme of training, both in UK, but also what became regular training sessions or seminars in Cyprus. Mr. Ioannou was present at a London session, and so on. So he's clearly got that in mind, and it covers the allegation that Mr. Ioannou was the hub of the marketing scheme. I could move on to paragraph 13 of the judgment, which is a long paragraph with many sub-paragraphs. We looked at part of it yesterday when we were looking at contract arrangements, but at 13.2, which appears a few pages on from the extensive extracts from the contracts, he picked up on the DVDs. I think that may be page 62 of the bundle, but my pagination isn't quite the same as everyone else's. Yes, I think it is. The DVDs, they were provided by APP, as they had been to UVR, undoubtedly issued and provided to potential customers as part of the sales package by the sub-agents with APP's authority. The script was read by Miss Nurse. The contents were plainly approved by Mr. Ioannou, was the finding of the judge. All the present claimants received or watch one. Then he dealt with training at subparagraph 3 and set out what it consisted of. 4 lines down, session seminars regularly attended by Miss Nurse, other employees of APP, usually attended for at least part of the sessions by Mr. Ioannou. The agents or sub-agents were addressed not only by APP, but also by the solicitors and by representatives of the bank. A little bit of doubt as to exactly who, how many Mr. Ioannou attended, but there it is, no question that he attended several. And then he concludes, carries on with training lower down in that paragraph. At such sessions, ROP UK provided to the sub-agents such as Mrs. Wellesby or Miss Brown, as we heard yesterday, detailed instructions such as contained in various documents, and he's identifying those. And then over the page at Roman 4, again he carefully looks at the brochures. They were provided by APP.
Approval.
And indeed, approval there. I'm satisfied he approved the content. And then reference to presentations and so forth. And then finally, the website, which in fact I don't think the judge in fact mentioned at paragraph 59, but nevertheless it's plain that he's had it in mind and he's recited it carefully in his judgment. And he was satisfied that was used and available.
Well, he's rejected Mr. Ioannou's evidence that it was just a pilot and wasn't available, and says he's satisfied it was in fact used and available on the website, and it was contained in brochures. So we've got active involvement, certainly by way of approval of the content of the brochures and the training sessions, attendance at some of the training sessions, although not obvious active participation in terms of saying anything, and being described basically as the managing director.
Yes, indeed. And there is also, there are more matters, I think, taken into account at paragraph 17.
Before you move on to 17, at 14, the judge says the combination of features entities to persuade me the agents had authority to make the representations which they then made. That authority has been conferred on them by Mr. Ioannou.
Well, it's been conferred on them by the company.
Indeed, but the actions were those of Mr. Ioannou, all of them referred to, are they not? So it must be, the judge must be finding by the company.
Yeah. Yes, absolutely. So he's done all of that, and then
if you look at each of the things you've gone through, I think all of them are actually, particularly several of them, all the judge says is that Mr. Ioannou approved it. He doesn't even say on behalf of APP, but that's plainly the force of his finding, and indeed is why he ends up finding APP liable.
Yes, absolutely. It has to be that, of course. And then just to continue on matters which plainly the judge took into account, if I move on to 17, he said he accepted the evidence of the claimants, all these statements in similar terms being exactly what was attended by the defendants as part of the master plan. They were induced to buy by the buy-to-let receipts covering mortgage, covering outgoings representations. The question is whether the representations were false, that the properties were not lettable, and that's something that he moves on to, but we don't need to deal with. And the rest deals with lettability. But at any rate, he is clear that he has taken all those matters into account as being part of the master plan upon which the claimant's case against both defendants was so firmly placed. So, in my respectful submission, what in fact has happened here is that the judge, having asked himself the right question, as he records and as is accepted at paragraph 62, then answers it in the way that he does, having taken into account that long list of matters that have been identified there. Now, there is, and forever no doubt there will be, a difference between the claimants and the defendants as to precisely how much activity on the part of Mr. Ioannou these various items involved. And of course, I was seeking unsuccessfully to persuade you yesterday that his role was far more peripheral than the judge found, and there it is. There was and remains a theoretical difference between the parties. But putting that to one side, what is quite clear is that the judge was quite satisfied as to all the items that he has quite laboriously enumerated there, but not repeated item by item, either in paragraph 59 or 62 of his judgment, and has come to the conclusion that notwithstanding, those items notwithstanding, or having taken all those items into account, Mr. Ioannou is both on the right side of the line for the purposes of a Williams type of liability, and also on the right side of the line for the purposes of an accessory liability. And
you needn't worry about the first, because that's not being pursued.
Well, of course, absolutely. But what I understood my learned friend to be submitting at least at one stage of his submission was that at 62, the judge really is only dealing with Williams and isn't dealing with accessory at all. And in my respectful submission, that's not right.
I think what Mr. Nathan was submitting was that there's been a blurring of the lines between the two legal tests, and so the judge doesn't directly ask himself the question, which is stage one, is what he did sufficient to foist him with personal liability if he wasn't a director, before coming on to stage two, which is, can he get out of jail by relying on the fact that he is a director and that he's acting within the scope of his authority. And so I think the criticism that's being made is that the judge has sort of melded the Williams point with the Fish and Sea Shepherd point.
Yeah.
And one can see a certain amount of force in that criticism, I'm bound to say.
Well, only to the extent that he hasn't, in fact, spelled out the words from Fish.
Yeah.
I think the second criticism, the second criticism, as I understand it, is the judge has quoted the test of participation or involvement in ways which go beyond the exercise of constitutional control, but he hasn't given any reasons, or not reasons which seem to address the point, as to why any of the acts identified are all covered by constitutional control.
Well, he hasn't spelled those out, and one rather suspects that what one finds in these types of situations is that, at least to some degree, the judge who, in this particular case, has listed some 26 or 27 days of evidence, has formed a very clear impression as to the role of the particular party involved. He's already, in his judgment, identified what that role has, what he finds that role to have been, and his conclusion, arising from the impression that he's received from all the evidence he's heard and his summary of the facts as he sees them, is that this particular party, Mr. Ioannou in this case, is the right side of the line.
Undoubtedly, that's right. But as we've seen this morning, I don't think it's a straightforward question. And the judge hasn't engaged in the question at all. And what's the difference between which of his acts were exercising constitutional control and which were not, and what defines the difference?
Well,
And maybe you say, well, he thought they were all constitutional control, and that's all he needs to say. But from what we've seen this morning, particularly the authorities, which he was made aware of, he doesn't seem to have grappled with that point at all.
Well, he certainly identified what the point is, and in the admittedly slightly shorthand way that he does in paragraph 62. Nevertheless, he's identified the area that he should be looking at, and without spelling out one by one which item is involvement which is irrelevant, one part which item is an involvement which goes beyond the exercise of constitutional control, or which thirdly item is an element that stays within constitutional control. His overall impression is that the conduct, and he's set out all the conduct, falls the right side of the line.
I think the difficulty that is pointed out by Mr. Nathan is that if you take the matters that the judge found as a matter of fact that Mr. Ioannou did, Mr. Nathan says, well, given the nature of the tort, which is dissemination of misleading marketing information, Mr. Ioannou is found to have been personally responsible for the content of the brochures, not just giving his seal of approval to them, but actually being much more involved than that. And that would be enough for a consultant or some other individual to be foisted with liability, unless it can be said that he falls within the narrow exception. Now, it may well be that you say, well, you don't get there because on the facts that the judge has found, it doesn't foist him with personal liability at all, in which case you don't have to worry about whether it's within his constitutional power.
Yes, well, I accept that, and I understand that.
I just wondered if that was the way you were putting it, or whether you accept the proposition that I'm not quite sure whether the submission that you've just made is a submission that on the judge's fact findings he falls on the right side of the line even before you get to the question of the exception.
I submit that is, I do start from the proposition that is what the judge appears to have done, and that short of reanalyzing the facts that he took into account in this court by going back over them in detail to see exactly how much control Mr. Ioannou had over the training process, or exactly what it was that he did in relation to the brochures, exactly what he did or did not say to the agents and so forth. Short of that, this court should be very slow to interfere with what plainly appear to have been the judge's findings of fact. And I refer no doubt to the well-known cases of Farge and Henderson, which consistently.
I'm not sure that there's a challenge at the moment to the findings of fact. The challenge is as to what conclusions the judge did or did not draw. I mean, did he conclude that there was participation and involvement, which, if it wasn't for the fact that he was exercising constitutional control, would have meant he was liable? And did he find, or did he find that he did participate or be involved in that way, but it was beyond, but did not go beyond the exercise of constitutional control? And I can't immediately see from the judgment which of those he was finding, or whether it's both. Well, it is undoubtedly a rolled up finding, and he certainly. I'm not sure you can maintain, can you, that he's really addressed and given reasons for this finding.
It's undoubtedly a rolled up finding, and I am stuck with that, as it were. But
which is why you may need to help us with a substantive argument.
Oh yes, no, well, I'm going to move on to that in one moment, but as I say, my starting point is that notwithstanding that it is a rolled up finding, the fact is that what he has found is that the whole long list of facts that have been recounted in this judgment do not amount to the requisite degree.
But we know that because that's what it says.
Yes, absolutely.
Question is, do you accept? There are no reasons here.
Well, he hasn't said the facts that I've recited don't amount to participation or involvement in ways that go beyond the reason of exercise of control because.
No, because what he goes on to say, the last 8 lines of that paragraph, none of those seem to address the point he's just.
No. No. And indeed, the first 3 of those 8 lines go back to the Williams. And the rest, in a sense, is merely an apology to the claimants.
I mean, I think where I would value help particularly is distinguishing the facts that the judge has found in relation to Mr. Ioannu's participation from the facts of cases such as MCA and Charlie, where you've got a director getting involved personally in bringing about, let's use neutral language because procuring has actively been involved in procuring certain acts which turn out to be tortious. So in MCA and Charlie, there's a certain coloration to the acts. But even so, you don't have to show that it's known that they're tortious. You've simply got to be personally responsible for the acts in question. And aren't the findings of the judge similarly that Mr. Ioannou is personally getting involved in the content, the design, and the issue of the sales pitches in the DVDs and the brochures and everything else? In which case, where's the point of distinction between this and MCA?
Well, one important point of distinction I would submit is that this is a case of omission, not a case of commission.
Yes.
And that is important. We get from Fish and other such authorities a clear steer of what it is that is being looked for. So that, for instance, in Fish, which is tab 30 of the authorities bundle, paragraph 37, which is Lord Sumption's judgment, after having recited earlier authority and quoted from Clark and Linson, says that the effect of these statements is that the defendant will be liable as a joint tortfeasor if 1, he is assisted in the commission of a tort by another person, 2, pursuant to common design, and 3, to do an act which is or turns out to be serious. So we're clear. He is clearly speaking there in terms of commission, not omission.
Yes, but we've got to be a bit careful about terminology here.
Yes.
Commission of the tort merely means bringing about all the necessary ingredients to make it actionable. And the necessary ingredients of the tort here are not the making of a positive factual misrepresentation which is untrue, but the making of a representation which is not entirely true because certain bits of it are it's a failure to give advice, isn't it?
Yes.
So it's a painting a particular picture of the investment without giving the downside.
Well, that's right, but the tort is a tort of omission, and the judge found that in terms of 38.
Yes.
In my submission, the tort is. Well, I'll identify exactly what he says. He identifies first 4 lines down in paragraph 38 of his judgment. The defendant plainly owed a duty of care in marketing. So, and that does mean doing a thing. Their wonderful new mortgage is a fundamental part of the offering. So he identifies what the duty is, and then he goes on to what the breach is, to put these claimants on notice of the risks, which should have been obvious to them, and to include a caveat in their brochures, rather than the trumpeted advantages of that special exclusive mortgage arrangement. I conclude that the defendants, by their agents and their literature, and pausing there, that means vicarious liability and personal liability, were in breach of duty of care in failing to advise, not in promulgating something that was untrue or misleading or whatever else it may be, but omitting to give a necessary piece of advice. And that necessary piece of advice could have been given in one of two ways, either in writing in the literature or orally by the agents at the meetings. But it's a sin of omission.
Well, it's an omission bound up with a commission, isn't it? Because the obligation to advise only arises because they are putting forward financial proposals without mentioning the risks.
But the commission isn't the act that's being committed is not the tortious act.
Well, you cannot.
It's
It's slightly difficult. For instance, with intellectual property breaches, you can say that the infringement, there is a commission in infringing, or you can say it's an omission in failing to obtain a license. I'm not sure it's terribly helpful to be classifying in terms of commission or omission. Well, often they're two sides of the same coin.
Well, it was something that exercised Mr. Justice Lindsay in the Società Explosivi case, which is in tab 41 of the bundle, and I could come to that. In fact, I might as well come to that now since we're there, because that was another intellectual property case.
I didn't catch the reference. That was
Sorry, it's Società Esplosivi Industriali (SPA), and Ordnance Technologies.
No, I'm sorry, it was where we find it. I didn't hear.
That reference is tab 41.
41.
And in short, that was a case where the defendant was alleged, the corporate defendant was alleged to have breached the intellectual property rights of the claimant. And then the question of the defendant's director, who was called Mr. Cardy, fell to be considered. And the section of the consideration in relation to his liability starts at paragraph 74, in which Mr. Justice Lindsay set out the law and quoted Lord Justice Chadwick's 4 propositions in MCA records and so forth. And there's a long account of all of that. But his conclusions on that case, we can pick up, I think, at best at paragraph 95, and from there onwards, where he said this, on the evidence and so far as concerns DMP, which at the moment I can't recall who DMP was, but at any rate, he carries on. The defendant company committed breaches of the claimant company's design right, performance by the defendants of its unseen contract as to the product DMP, that's what it is, did not necessarily involve breach of a design right, but Mr. Cardy, who was the director, knew that unless he took appropriate steps, the breach would occur if the employees were in broad terms merely told to proceed with the creation of this product. Had he taken... Thank you. I'm told it's a metal protector of some description. Had Mr. Cardy taken appropriate steps, the misuse of the design right in the project would not have occurred, and Mr. Cardy, as the person holding himself out as the managing director and his sole director and shareholder, had amongst his task directing the defendant away from its committing any such breach. I've been given no reason to think that he didn't have total control. Yet for all that, just above B, well, you may not have the All England report there, 3 or 4 lines down. Yet for all that, it hasn't been proved that he gave any instruction, which in terms was that the ownership, sole or shared of design rights should be ignored or breached, nor any instruction that would necessarily have led to its breach. And then at paragraph 98, if that is the factual basis, that Mr. Cardy intended and procured and shared a common design in the events amounted to infringement should take place, plainly Mr. Cardy had failed to prevent the tortious acts, but would that be enough? Counsel was not able to draw my attention to any case in which a defendant had become a joint tortfeasor by means only of having failed to prevent the primary tortfeasor's tortious activity, despite the defendant having power to do so. And I'm not aware of any, I've not been able to find any cases to that effect either, I'm bound to say, my lords and my lady.
Well, you wouldn't normally be liable as a tortfeasor, director or no director, for failure to prevent something from happening. It's the age-old story about the person who stops, who doesn't intervene to stop somebody falling into a lake or something of that nature. There's no tortious liability. But there is a distinction in kind, is there not, between a failure to act to stop the company from doing something which turns out to be tortious, on the one hand, when it would have been within your power and control to do so, and active involvement in bringing about the act which turns out to be tortious. And in this case, we've got Mr. Ioannou, who's said to have personally been responsible for the issuance of brochures and the design of the brochures and the content of the brochures and the scripts and so forth. And if that design and content and script is going to attract a tortious liability because it omits to mention the risk, then surely he's not in the position of a mere passive person who is failing to get involved.
Well, I would say that he is, for this reason. No one has suggested that he wrote the scripts, and in fact, the fact that they, without wishing in any way to be rude to him, the fact that they aren't in foreign English, as it were, would rather suggest that he didn't. So that he is in the position of having the script put in front of him, and he says, "It's great to me, off it goes."
Yeah.
At that point, he has the opportunity to say, "Hang on, there's something missing here, and we really ought to do such and such." He omitted to do that, and the script omits to contain the words that the judge found in paragraph 38 it ought to have had, the caveat. In my submission, that is all omission, not commission. And that has to be, in my submission, the realistic analysis of how this works.
But Mr. Justice Lindsay's analysis here isn't addressed to omission or commission, is it? It's addressed to prevention or procurement or prevention, isn't it? Which is a slightly different thing.
Well, I venture to suggest it isn't a slightly different thing, because I mean, essentially, what Mr. Justice is concerned, he found a way around it. He went back through the evidence, and on the evidence of that case, as it happens, he came to the conclusion that actually there was active commission by the director in certain ways.
I think, if you forgive me, I think you're confusing the question of whether the tort is one of omission or commission, and whether or not the Accessories Act is one of omission or commission, which are different questions.
Well, if it sounded as if I was, I certainly didn't mean to. In as much as, in this case, the tort is a question of commission or omission, and I would say that the accessories action is probably the wrong word. The accessories involvement is also one of omission.
You say that by the most activity on the part of Mr. Ioannou that one can point to on the judge's findings is approval. He has, as the director, approved the literature, and he's gone to the meetings and occasionally pointed out that perhaps somebody needs further training.
Yes.
That's what he's done. He's approved. He hasn't corrected anything that might have come to his attention in the literature that is wrong or missing, but there's nothing to suggest that he was alerted to it. And you say mere approval of the literature is not the same as personal responsibility for its design and its content, which is not part of the fact findings and which might go the other side of the line.
It might, yes.
Right.
It wouldn't necessarily in all cases.
So approval is sufficiently neutral or passive as to not amount to trespassing beyond the role that you would expect any director in his position to have, which is to sign off on the content.
And I would say that signing off on content is very much a form of constitutional activity.
Yes.
And if I recall my learned friend's submissions accurately, he wasn't able to go so far as to say, Mr. Ioannou, when these brochures came across his desk, said either, for heaven's sake, don't put in a caveat, or phew, there isn't a caveat there. It just didn't come up at all. And again, that's very much more the situation of omission rather than commission on his part. And as we know, as the judge has found, not only is that the case, as I would say, but also as the judge has found, the tort itself was a tort of omission, to which these cases just don't address it. But conceptually, I would submit that the notion that one can be by an omission, one can be an accessory to a tort of omission, is moving quite a long way away from the authorities that we're looking at in my submission. And conceptually, I would say also there's this further difficulty that I would suggest with the case that the claimants put against me, and that's this, that we're looking at, actually, it may be the same point, but I'll put it slightly differently. We're looking at a Headley-Byrne type of case. ESSO is an extension of Headley-Byrne. And Headley-Byrne itself is a niche area of tort law, if I can put it that way, in as much as it's an extension of old principles, if I can put it that way. And it's very much dependent on assumption of responsibility. The judge has found that by putting out its literature in the way that it did, the company assumed a responsibility for its contents. The judge has also found that Mr. Ioannou did not assume a responsibility for those contents. And it seems very difficult to see how one can say, on the one hand, that he did not assume responsibility for its contents, but nevertheless, he can have directed or procured the assumption of responsibility by his company. And bring him in that way, in circumstances where essentially the judge has come to the conclusion that there's no other legal basis for imposing upon him a Headley-Byrne type of liability. And that's
I find that difficult. I'm not sure why you can't direct and procure that the company assumes responsibility without yourself assuming responsibility.
I don't think you even need to go that far, do you? Because surely, if the situation is one in which the company has assumed responsibility for anything that it promulgates, that the accessory liability arises for being responsible in a personal way for that which is promulgated. So I don't think we even need to go to the extent where he's got to accept an accessory liability for the assumption of responsibility by the company.
Yes.
If there is that assumption of responsibility, if you are against a factual background where the company is responsible for the literature that it's promoting because in the circumstances of the case it intends it to be relied upon and it is in a better position to know about the scheme than anybody else, why is the director, it seems to me that the question of whether the director has an accessory liability must turn on his personal involvement and whether he is in some way responsible personally for that which is promulgated by the company, bearing in mind that it's assumed that responsibility.
Yes, I can see that, and that in essence is what we learn from Fish and those other cases.
But you say this case is on the other side of the line from all of those cases because he's done nothing more than approve the literature and be present at meetings at which the sales pitch takes place. He has not been shown on the evidence to be personally responsible for the fact that the literature doesn't contain the warnings.
Yes, indeed, and moreover, that if there is to be a proper distinction between omission and commission, that in approving the literature, or at worst, he's omitting to do something which he might otherwise have done. What he isn't doing is, as I say, is saying, make sure that they aren't told X, Y, or Z.
Is this a convenient moment for the 5 minute?
Yes.
Yes. All right.
I mean, that's because of the...
If he doesn't exist at all, then why should you be? Yeah, well, that's what I'm going to try to do. Well, anything that's more but I mean, no, I mean, yeah.
It's the second, paragraph 36. attended by training sessions.
Yes. Oh, I know.
It's the bit I didn't ask.
Yes.
Bottom is 36. No, it doesn't actually say anything about that. What you read was it's obvious. Company.
Yeah.
Yes, when I read solicitor. It's a deliberate. Because it was a deliberate. Yeah. So all that I really want to say to them is that it was a deliberate omission.
As a combination. What the case was, and when the judges find 38.
Well, I've already made that point before. I made it earlier. It was obvious.
Yes.
Oh, I see what you mean. It was a conscious omission.
Yes. Which promises.
Very good point. Yeah, I like that. Do you see yourself going past the 450 mark?
I don't see myself going past the 335 mark. I mean, I need to finish.
Very good. Okay, good.
But anything that really you have to be doing something relatively interesting. Oh, really? Security. Yeah. See, essentially what's the way? Security, and then this is the thing.
Court rise.
Yes, Mr.
My Lord, unless there are specific further questions that you would find it helpful to hear from me, what I really wanted to do was just to wrap up my submissions at this stage by emphasising the core points that I'd be inviting you to take into account.
Yes, I think that would be very helpful.
The first is that Mr. Ioanou's signing off on the brochures or the his attendance at the training session amounts to no more, in my submission, properly viewed as the exercise of his constitutional role within the company, and that what is quite clear is that so far as the commission of any tort is concerned, the judge has not found against Mr. Ioannou that he actively took steps to ensure that the contents of the brochures or the contents of the agent's representations were so framed as to keep from the ultimate purchasers the risk and to keep it from them, as I say. That being so, in my submission, it would not be right to analyse his activity as assisting in the commission of a tort by another person within the wording used in Fish. And at its highest, the fact that he let the brochures go out, or he allowed the agents to set about their sales pitches to the customers in the terms that they did, was in essence no more than a facilitation of the tort that was thereby committed, namely the omission to include the important caveat in each of those cases, in each of those types of situation. In my submission, there is nothing to suggest that he applied his mind in any way to ensuring that those important warnings or caveats were left out. That's certainly not consistent with anything in the evidence or indeed with any finding that the judge made. His only error in my submission was to allow the agents and the brochures that he signed off on to talk up the mortgage without the offending, or rather the necessary caveat being included. There's nothing to suggest that he gave the question of the caveat any thought, and it's exactly for that reason that the judge didn't find anything other than a negligent failure to advise in the way that he articulated in paragraph 38 of his judgment. All of that, in my submission, means that this is far from being a case on all fours with the fish and lifestyle and other line of authority upon which the claimants rely. A difficult and different case, which focuses on a factual situation that, in reality, appears not to have been canvassed to any degree in the authorities at all. The most that one can see from authorities, and it's difficult to tell. It's difficult to say very much more about it. Is the reference to the first instance decision in Challoner and Bellis that your lordship, my ladyship, finds in paragraph 44 of Lifestyle. It's tab 35. Challoner and Bellis is a 600 or so paragraph first instance judgment, which I think you will find in your bundle of authorities, but I'm not proposing to go through it.
So it's 44 of...
Paragraph 44,
Yep.
tab 35.
Thank you.
Lord Justice Burse refers there to the Challoner and Bellis case. It was a case in which there had been a promotion of an investment scheme. And part of the claim, that's about 6 or 7 lines down, part of the claim involved allegations of misrepresentation by Mr. Egan. At trial, both his firm and the claimant had claims against him. Claimants claimed that he personally owed a duty of care, which he breached by making misrepresentations. The defendant firm claimed a contribution from Mr. Egan on the basis of breach of fiduciary duty and dishonest assistance, and also claimed he was personally liable. 45. The judge rejected the misrepresentation claim, went to consider other aspects of his position in his conclusion was wrong, rejected the claims against him personally by both parties gunning for him. The issue of Mr. Egan's liability as an accessory took up 5 paragraphs in an 800-paragraph judgment. The judge noted the defendant firm had not elaborated its argument beyond simply citing MCA and Charlie and Standard Chartered in Pakistan. The judge quoted passages from MCA and Charlie, then stated a conclusion without elaboration that Mr. Egan was not liable because he cannot be said to have stepped outside his remit as a director or employer, or otherwise acted otherwise in a discharge of his obligations and perceived them as such. Lord Justice Burse didn't agree that that was a sufficient basis to find a non-liability as a tortfeasor, but for the reasons that he explains in the remainder of that paragraph, the point fell away and it no longer matters. So his criticism there was as to the judge's reasoning, or least the lack of evident reasoning. And to that extent, that is obviously the criticism that's made against Sir Michael Burton in the current case. The only reason that I draw that to your attention was because that is the only case that I'm aware of that even is a representations case, as opposed to the line of trademark infringement and shipping cases that your lordships and my ladyship have been shown. And in the result, it doesn't actually tell us, in my submission, anything other than that the learned Lord Justice was critical of the judge at first instance dealing with that particular point as shortly as he did. And as I say, that it happened to have been a misrepresentation case, which appears to be about the only one of which I'm aware. But I thought it was right that I should at least draw that to your attention. However, going back to the main point, the main point here is, as I've submitted, that in a situation where one is dealing with omission rather than commission, we move out of the strict fish and lifestyle territory, because those cases, in essence, don't assist for the reason that the requirements of those cases do require commission by the person, commission of an act by the person accused of being the accessory, and commission of a tort by the primary tortfeasor, who has been put up to it, as it were, by the accessory. What we don't have in this case is any basis upon which it can be said that what Mr. Ioannou didn't do, in other words, didn't apply his mind to the necessity to include a caveat in the marketing literature or in the training materials. It is sufficient to bring him within the defined category of accessory as identified in the case law, such as to prevent the ultimate tortfeasor, the company, from promulgating that mistaken literature which contained its failure to advise. For those reasons, in my submission, you should leave the conclusions of the judge, however briefly expressed, untouched. And as I stated at the outset of my submissions, you should take the view, in my respectful submission, that the judge, whilst not expressing himself as fully on the application of the test in paragraph 62, as he should have done, nevertheless did ask himself the right question, and from the evidence it can be shown that he took all factors of Mr. Ioannou's conduct into account in coming to the conclusion that he hadn't crossed the line, either in a Williams sense, which is not relevant to this appeal, or in the MCA fish lifestyle sense, which is. So, my lord, that's how we put it on this side. Unless I can help you any further, those are my submissions.
No, well, thank you very much indeed, Mr. Parker. Yes.
Very shortly, my lord. First of all, on the last point about asking the right questions, I hope that my lord and my lady have got the point that we say that the judge sort of asked part of the right question, but didn't ask the right questions in relation to this aspect of the claim, because he necessarily needed to have an inquiry first in his own mind as to whether or not the fish and fish test had been satisfied, and that was a necessary first step along the way, on the footing of ignoring whether or not Mr. Giuliani was a director. The second step was to consider whether or not he fell into the exception. But the way the issue is put is not really put in the form of an issue. It's simply a conclusionary statement made by the judge without giving any basis at all for how he has arrived at it. The second point is that Malone Friend seeks to say that somehow that the omission and commission can be distinguished. We respectfully say, in the circumstances of this case, the court does not actually need to be concerned, because an omission is, first of all, not a neutral thing, but here, what the judge has found, rejecting, well, it was the subject of Malone Friend's ground of appeal, as set out in paragraph 30.3 of his skeleton, when there was the challenge to the judge's finding about obviousness of the risk. Effectively, my lords have rejected that. The judge's conclusion was, not only was it an obvious risk, but an incredible risk. And I was in the sense of it is a very large, obvious risk to the company, and obvious therefore to the company, and obvious also, it follows, to Mr. Giuliani in the circumstances as being the driving force behind all that was going on. And that is very important, because this was therefore not just an omission because he was being forgetful or something of that kind. It was obvious and incredible, and it must have been a conscious omission. To omit telling the public anything at all about the risks, and in particular this risk. And importantly, it wasn't just a single thing, it was a continuing conscious omission not to tell the public. And therefore, what one can characterize it as being a conscious act of abstention Now, that puts it into, or puts it in a form of words, which in fact makes it not simply a neutral omission, lapse. It's actually something which was done, we respectfully say, consciously, deliberately, because it was so obvious. The only reason for omitting to do so would have been to decide not to do it. As a matter of...
Was it put to Mr. Ioannou that this was a conscious, deliberate decision not to explain the risk?
I cannot honestly say in my own, from immediately, I can look it up again, but I can't honestly now recall whether that was specifically put to Mr. Ioannou as being obvious. I think it was, but I can't remember the precise way in which it was put, because it was something which was being...
well, if you find a reference which shows that it was, please give us that within the next 24 hours.
Yes, certainly, my Lord. We'll go back this afternoon and do that. So one has the position where Mr. Ioannou, and to pick up from my lady, Lady Andrews' point, that the activity, there is clearly a massive activity carried out by Mr. Ioannou, part of which is this. And even if it were simply to be characterized as something which got forgotten about, nevertheless, the publishing of material which omitted this obvious risk is something which I would respect to say nevertheless still comes within those three conditions of required in fish and fish, but I would prefer the first way because it makes it that much more obvious, obviously within those three conditions. And that's how we would like to put it. I don't think there's anything else, unless Milan Junior's got something point to that I ought to be making to my lords in support of our appeal. But the only thing I would say, obviously I rely upon what's in our typed scans, goes without saying.
Well, thank you very much. In fact, thank you both very much. We will reserve our judgments. We will, as you appreciate, not be sending you a draft before the end of term. If we are able to produce a judgment during the vacation, then we will circulate to you and hand it down. But at the moment, I better not make any promises about that. I hope my clerk has been in touch with you. If not, I'll make sure that she is, about obtaining email addresses of individuals to whom, in due course, she has done that, has she? It's been very good. All right, I won't say any more about that then. You will be aware, I'm sure, of the concern on the part of the court arising out of the Counsel General for Wales case and the importance of the embargo which attaches to the draft judgment. But I draw that again to your attention, and I'm sure that will be explained to all those to whom the draft judgment is provided before it is handed down.
There's one aspect which is at present only the claim one claimants are parties to the judgment. They would be therefore permitted within limitations to know what to see the draft judgment. But we would not consider at this stage any reason to let it be known to the other claimants.
No, you should certainly not do that until it is formally handed down. The purpose of providing it to you in draft
Is to
enable you to make
corrections.
suggestions for corrections and matters of that nature, and to deal with any consequential matters. The extent to which it is necessary for individual claimants to see it for that purpose.
Well, we're very conscious of that. It's one of the matters which I only raise it really to emphasise our consciousness that we have, because there's so many of them, and very reluctant to tell them anything.
You may find that it is sufficient for your purposes to tell them the result in order to obtain any instructions you may need about costs of omission or anything of that nature, without even giving them the written judgment. I would have thought. If you do give them the written judgment, then they must understand the terms on which it is provided, and you must satisfy yourselves that they do.
Certainly.
Very good. All right. Well, thank you very much. That concludes the hearing.